So continue with. Can y'all still hear me? Can y'all still hear me? Yes, no, maybe. Did the stream stop for you? Did the stream stop?
It stopped.
Okay. So what I want you to do is refresh. Did the stream stop for you? Okay. Well, now we're live again. Okay. So go ahead. Now you were talking about. We were talking about fair use. Could you turn that down a little bit, please? Go ahead. Now you were talking about. Who's? Okay, we got it fixed. Okay, cool. Continue talking about what fair use is versus what we think it is.
Okay, sure. So fair use, it allows the fundamental purpose is to allow you to engage in your own expressive endeavors, speaking, talking, painting, drawing, singing, all that. And the point where something is fair use is if you need to be able to comment on something, or you have some kind of transformative work that takes an existing work and makes it something new, and it's a necessary part, that pre-existing work is a necessary part. Generally, those are where you're talking about things that are fair use. So, for a great example, a documentary filmmaker saying, "I'm going to do a film on the subject of, this one artist and his life." And to talk about the artist and his works, you probably need to show some of his works.
Yeah.
And so that's an example where fair use might come into play, depending on how you do it. What it isn't, and there's a common misconception, is hey, if it's online and it's out there and people are using it, it's fair use. I could use it too. That's wrong. There's no such thing as fair use because other people use it too. There's also a misconception that there's some kind of rule of thumb about, hey, I'm going to use this piece of music, I'm only taking 10 seconds, so it's fair use. That's not going to be, there's no bright line rule on that.
Really?
While we do look at how much of an underlying work is taken, there's a real misconception of that there's some kind of, hey, I'm safe because I only took 10 seconds. That's wrong.
Okay, thank you for clearing that up.
Yes, clear as mud.
Okay, all right. So, that said, it's a very common practice still for people to use Google Images. I mean, it's there, it's ready to use seemingly, and you need something for your blog post to make it pop, make it stand out in the timeline. So people, automatically go over to Google Images. But what's the risk in doing that?
The risk is huge, because Google Images is completely separate from the public domain or fair use or the right to use an image. And so it's really problematic to do that. Before you use a photo in your blog, you need to make sure you have the rights to it. If you didn't create it yourself, you didn't snap that photo, then you need to get those rights from whoever did. Now, Google Images doesn't give you that. And one of the things that's really scary about Google Images is you can now search for photos that are tagged for reuse. So this happened to a client. They're a blogger, and they said, hey, no, look, we're good. We understand all this. So we filtered our Google Images results to photos that are flagged for reuse so we could reuse them. We're trying to be great. And problem is, one, there was a photo that shouldn't have been in there that was improperly tagged. And they got a cease and desist, and we're discussing what the owner wants, and right now there's a several $1,000 demand that we're dealing with.
Wow, yep. That's a costly mistake.
Right, because it's not a defense. There's no, I tried my best. It's, you didn't have the rights. Wow. And I don't care what the courts and the law don't care what Google had to say about it.
Okay, so everybody has been warned. Leave the Google Images alone.
Right. Now it could be, you could use it as a starting point. You can see what's flagged for reuse and go from there and dive deeper. Okay, where did Google Images get it? Did it get it from this author's site and they put it out there with a Creative Commons license? So it could be a first step. don't just rely on Google Images and take photos and use it on your blog. I've helped several clients every year who have backlash because they've done just that.
Wow. He did say several clients, people. You don't, not to take any clients away from you, but you don't necessarily want to be in that position.
You don't want to be my client in that context.
No. Okay. So that said, speaking of video, because a lot of people, just seem to think Google Images and they always think just pictures. But the reality of it is, even when you are recording video footage at a public event, you can still get a real big cease and desist because of what you thought you were recording at a public event. So go a little bit into the big issues about recording. Oh, my son is at the baseball game. Oh, my daughter is at she's opening, or she's doing something or the other, and you don't have a careful eye about what else is in that image besides your son or daughter.
Right. Okay, sure. So, to some extent, that people think, and the instinct is right, but it's not as absolute as people think, that I'm out in public, I can take video and I can post it. I think the sentiment there is, hey, this is all public. People put themselves out there, so no one can own just what's out there in the public. Why can't I do it? Mm-hmm. And to some extent, there is a little more leeway where people have a harder time complaining when they put themselves out there in public. On the other hand, it's not absolute. So the kinds of things that we help clients look for are those copyrightable works, copyrightable art. Someone might be wearing a t-shirt that you're focusing on, and there might be a copyrighted work on the t-shirt. There can be music playing in the background, and some band, some publishing company, they own that music, and we've seen those things get litigated if, hey, I want to take a video of my son or daughter at this event, and hey, they're dancing to this song, and I'm going to have the whole song in there. That's copyright infringement of that song.
Wow.
So that's an issue. You also have issues that we counsel clients about on rights of privacy, rights of publicity. Mm-hmm. The right of publicity is the main one. We might get into this in another context, but people have a protectable right to make commercial use of their own image and likeness and name. Mm-hmm. And so if you don't have their permission and then you're using their image, likeness, name in a commercial way, then that can also cause trouble. Now, if you're purely blogging on your own personal, hey, look what I did this week and kind of blog, that's not a commercial use. You're not as concerned. If you have a business blog and it ends up on there, this could be a real issue.
Okay. Speaking of blogs, because there's a big thing right now with bloggers and having to literally say, this is a sponsored post. This post, I'm being paid to say nice things about this company. Is there any new rule or something that bloggers need to understand right now? Because social media law is still evolving, but this right here is probably only a couple of years old. Maybe was it the FTC rule is only maybe how long? How many years old? Bloggers?
The FTC rules for the applying to bloggers have only been the last couple of years. Mm-hmm. But that's mainly these rules have been there for a while. It's just trying to apply them to this new landscape, and that's what's difficult. Mm-hmm. Because the marketing it's immersive. It's this marketing. It's no longer so clear, right? Like 10, 20, 30 years ago, what was the advertising marketing? It's okay. I'm not watching my TV show anymore. I'm watching a commercial. I know that. And same thing. I'm listening to the radio. And then suddenly my show is going to commercials. I know those are commercials. And then you start having things like integrated marketing and product placements, those kind of things. Mm-hmm. So what the FTC does is they have regulations that just try to make it understandable. What can you trust when it comes to listening to endorsements? How do you know that, okay, I'm listening to endorsement. I don't want to be fooled and think that I'm really trusting this person just because of what they say, and I don't understand that they're getting paid to say it. Mm-hmm. So that leads to the issue with blogs, is that it blurs those lines, because you're in a blog, and say I'm a blogger, someone sent me a bunch of free samples or pays me for, I get back in royalties on a product that I'm pushing, and I'm just blogging about it like I do anything else, people don't understand that, or they may not, that I'm being compensated to do that. And so these rules require you to have these disclaimers. Back when it was self-explanatory, you didn't see them, but now you're seeing them in the social media context for that reason.
And now that Facebook is basically mandated, and even giving you tools, Facebook and YouTube both have given bloggers, YouTube vloggers, and the whatnots tools to make it very easy for you to say this is a sponsored post. So you really don't have any excuses anymore to let people know what's really going on. And you don't have to be a Kardashian or DJ Khaled, one of them.
Khaled.
You know who I'm talking about. Yeah.
Yep.
Okay. So.
And what some people don't realize is that it applies even to free product samples. Someone sends you some free product samples and you like them, and you're going to blog about the fact that you tried those things out and they're great. That's still compensation enough to trigger those sponsored ad disclaimers.
That's kind of interesting, because that makes me think about when I was an entertainment blogger, and of course, technically I'm considered media. To one end, I'm considered media, but journalists and bloggers sometimes look at each other real side eye. But but when you're invited to to an event, you're invited to a press junket, or you're sent a trailer, we don't, as media, as a blogger, you don't think, well, I have to tell you that the studio sent me this. That's not the thinking generally. So I'm wondering how that will start applying in the future. Probably may not apply right now.
Yeah, it's an interesting question, because whether it's compensation, it kind of looks into the value that's given, and I think there probably is a difference between being able to see something and comment on it versus I have this laptop that I'm now talking about, but then when I go home, I have this laptop, right? And it's got a lot of value to it.
Yeah.
So I think that's an interesting question to see how that would, if that'll get applied in the screeners and the trailers that we put out to media and the entertainment world.
And for those bloggers that are like, Alice, why you bring that up? I'm sorry. It just I'm just trying to save you in the future. Okay. So, speaking of shooting video, taking images, if you hire a professional or even an amateur to shoot video or take images at the wedding, at whatever the event is, who owns that footage and or those pictures?
That's a great question, and one of the most misunderstood points of copyright law. You hired that person, you paid that person, let's say you paid that person $10,000 to shoot that wedding and take that video. You still don't own it. That videographer, that person that you paid, owns the copyright in that work that they did. The copyright law says whoever the author is, the creator, the person who snapped the camera to take the photograph, the person who created that website, put together all those artistic elements for the website, that person owns it unless they're an employee of yours, working as an employee within the scope of their employment, which this person's not if you just hire an outside videographer to do this for you. Or there's a written agreement in advance that it'll be what we call a work for hire, and you will own it, which 8 times maybe out of 10, that's not there. And so you would need to make sure you have that written agreement. If that didn't happen, you don't own it, and it doesn't matter how much money you paid.
Wow. Okay, so that brings to this point, because a lot of people hire web designers. And the so what you're saying is, if the web designer bought the domain for you, if the web designer created the website for you, even though you may have the pictures, you gave them the pictures, but if they added extra elements, they created the WordPress, they did the Joomla, whatever it is, are you saying they own that website?
Unless there's that written agreement, they own the copyright in it. Copyrights can only be transferred if it's going to be sold or assigned, or even an exclusive license where you're the only one who has the right to use it. That has to be in writing. So what happens in those contexts is there is a provision of law where you can have an implied non-exclusive license from the facts. So a court would likely say, yeah, you paid money for your website, there's an implied license, you can use it, but then you see the fights over how big is that implied license. Do you have the right to go sell it? You have someone who wants to come buy your business. Do you have the right to sell that? Can that website design company come back and say, oh, that's outside the scope of what we contemplated, you owe us more money?
Okay.
And that's possible. That could be argued.
So even when you scroll down to the bottom of a website and you see copyright and the person's name, but they didn't build the website, that basically I just scared a whole lot of people. Or you just scared a whole lot of people.
Yeah, and I'm sorry about that, but that's true. That the website example specifically is probably the most common place this comes up when I tell people that. It's because it's so counterintuitive. I hired that company, I paid them money, I should own all rights in it, and that's why we try to get those contracts in there in advance. Because the website itself is copyrightable, even if, like you said, you provide the photos, you own your logo, and you provide the logo. Think of it like, a compilation CD, like a soundtrack that uses pre-existing songs. Whoever put together that soundtrack may not own each individual song. They may have got those from different places, but the overall selection of the music, putting them together in one album, that overall compilation has its own copyright interest. That's like a website. You combine other people's elements into one overall website, and you can have an interest in that website itself.
Wow. Well, I own a couple of websites I didn't even realize. It's a good thing I'm a nice person. Okay, so next question, and I'm going to skip around just a little bit, because I now that we're talking about websites and things of that nature, I kind of want to get into libel and defamation, because especially with the climate that we're in right now, and there's so many people rushing to Facebook, they're rushing to Twitter to share all of their angst about whatever is happening, either in politics or what's happening at work, and share what is the difference between libel, defamation, and what's the other word? I keep forgetting. Slander. That's what it is.
Yep.
What's the difference between the three?
This is very timely. I actually got a call about 3 hours ago from a business that a former client of theirs was on social media saying some things that this person this business viewed as defamation, and we're meeting tomorrow to discuss that. Uh-huh. So very timely, because this is happening all over the place. Mm-hmm. So defamation is the term. That's the kind of umbrella term here. Libel and slander are just two different versions of defamation. Libel is written, slander is spoken. Either way, so libel, written version of defamation, slander, spoken version of defamation. So when you're looking at it online, you post a video where you're saying things that are defamatory. That could be pursued as slander. You post and you write things on your Facebook wall, or you tweet out some defamatory statements. That would be libel. So what defamation is, what we treat as defamation are untrue statements of fact. So that's important. Opinions are not defamation. You're right to have your own opinion. You can do that, and that's not going to be defamatory. If they're untrue statements of fact that are published. So if you come to me and you tell me that, I stole money from the Rite Aid, and that's false, that's still not defamation, because you're accusing me to my face and just to me of it. Now, when you go out there and you, quote, publish it, which just means communicating it to a third party. You step outside my office and you tell my staff, you tell some client of mine, hey, Thomas Varnum stole money from Rite Aid. That just became defamation, because you've now published it to a third party. Okay. And obviously, you put things online, you publish the heck out of things. Okay. And then the third element is that it causes injury. You can't the law won't allow you just to get mad over nothing because your feelings got hurt. However, in North Carolina, we recognize what we call libel per se. So there's certain areas, if you are impugning somebody in their trade or profession, we're going to assume that causes damage. If you accuse somebody of having an infectious disease, that's one of those just black letter elements. If you say that someone's got an infectious disease, we're going to give you liable per se and a clearer path to winning.
Interesting. So, you know how people often say, just because I retweeted something or shared it on Facebook, I don't necessarily endorse it.
Yes, very good point.
That explain why that is not going to keep you out of court.
Very good point. Very good point. So again, back to the public. If you publish, if it's an untrue statement of fact and it causes harm, and you publish it, then now you're within the defamation laws. Now, publication can happen by republication. Mm-hmm. So just because you weren't the first person to say it, but then you, again, republish it as a statement of fact, then you've got a bullseye on your back. And this is why this is one of the things that we counsel publishers, newspaper publishers, magazine publishers, journalists are very careful about defamation laws. And so while you'll see a careful journalist will always say, so-and-so reported that Thomas Varnum stole money from Rite Aid. That kind of thing, because they can prove that somebody else said it. So the only fact they're saying is this person said it. They don't just come out and say Thomas Varnum stole money from Rite Aid, and make it their own statement. So that's the line there. If you just republish something because you heard it somewhere else and now you publish it on your own platform, that can, if you don't do it the right way, that could be publication of a defamatory statement.
Okay, so people who have happy trigger fingers and thumbs, who are easy and so quickly retweet and reshare things, might want to put yourself on pause.
Yeah, that's the thing with social media. It's so easy to publish without thinking or reviewing. It's not like other platforms where you have someone else who has to maybe sign off on it, or you have to go through step 2, 3, and 4 to get it out there. It's just so easy to say what you want to say, send, and then think, whoops, maybe I should have thought about that.
Wow. Okay, so now I want to delve into, for those individuals that are using social media as a part of their job. So yes. If you are an employee, and you've already basically answered that question about if you have some issue with your boss or your company, and you feel so inclined to go on Facebook and rant about that, you are putting yourself in a position to potentially be sued, because if it slides into defamation, correct?
Right. Well, yeah. Well, I think getting fired is your most immediate concern. I think most employers out there now, they have policies about social media use, and even if they don't, North Carolina is an at-will state, and it doesn't take much for an employer, unless you have a written agreement, if you have tenure or something at a school. So first off, you got to worry about whether your employer is just not going to like it, and you can lose your job. But beyond that, if it's out there and it's published and it's defamatory, and that you're saying something, presenting it as fact, and it's not true, yeah, you see just from the basic PR of it, some employers deciding it's better to take a public stand and say, see, this was so false, we even sued them.
But what if it's true? What happens if what you say is actually true?
Then it's not defamation. Truth is a complete defense. So that's why sometimes you'll see some bold journalists, once they've done enough research and they've built files, they say, look, if you sue me for this, I'll prove it's true. And that's a complete defense. Okay. But then you have to be very careful to make sure your statement is completely within what you can prove, and you didn't embellish, because that's where the person who thinks they've been defamed will get you.
Okay, you cannot stand on First Amendment right in this particular case.
No, definitely. This is kind of one of the exceptions to First Amendment rights. It's still, you still have the right to say it, but you got to pay for the damage you cause. Courts are still very reluctant to grant orders or make rulings that are what we call prior restraints of speech. So the court is very unlikely to come and say, hey, don't say that thing you're about to say, and those are First Amendment concerns.
Okay.
But then you say it, and you don't have the right to go lying and harming people. They'll come back and say, okay, you owe the person for the damage you caused.
Okay. So in many cases, when social media becomes part of your job, in many instances, it may become part of your job description a year or so later after you've already, had the job a while. When you create a profile as that employee, as a representative of the company, you build up a following. When you leave that company, you do not have any ownership, correct, of that profile. You leave that just like you leave the paper clips and the pencils, although you might take a couple of those in all honesty. But but everything. But as far as that profile, even if you built a following on it, that remains the ownership of the company, correct?
By and large, yes. And especially that's another evolving area. First thing you look for is, was there a policy manual? Was there something in writing that spelled that out? Now, lots of times you do see that, especially if you're in that kind of position where you're creating content and creating profiles. All of the content itself is going to be, if that's your job, is going to, the copyright interest, the ownership is going to be with the company, because it's within your scope of employment there. So back to that work for hire.
Yeah.
You were an employee, that all belongs to them. There have been some very interesting disputes. To my knowledge, they've all settled before they got to a final ruling by the court on things like followings having value, who owns them, Facebook likes. There was a BET case out of Georgia that was litigated. It was the closest one that I've seen to come to a final ruling, where somebody left and said, I own those likes. And then the court, kind of smoke came out of the judge's ears. How do I even understand the value and the ownership of likes? What are those? So I think that I'm not sure, it was a confidential settlement. I'm not sure exactly how that one shook out, under the agreement. But I think BET was looking like, as the hiring party, was in a pretty strong position that it owned the likes that were created within its umbrella.
Wow. Okay, well, kudos, BET. Yay. Okay, now, going back to something we were talking about before, as far as when well, let me start here. Right now, influencer marketing is really, really hot. And you've got so many individuals now using real and imagined celebrities. And for those real celebrities that enter a business, you have, like, I had one client who had a smoothie company. It was yogurt. It was one of those frozen yogurt thingamajiggies. And Britney Spears actually came into the business. So, of course, at that particular time, it was like, oh, Britney Spears came in, let's take some pictures. And then she tweeted about it. Technically, they saw it as an endorsement. They retweeted it. In that particular time, it was cool. I would dare say now, I don't know if that would still be considered okay, or if there's rule and regulations as in that we probably should have presented her with some paperwork or something or the other to get permission before we went. Even though she said this is great ice cream, this is frozen yogurt or whatever. Right. I would imagine we're at that point now where you need to have something in writing. Correct?
That's the safest route. I mean, it's a case-by-case scenario or analysis. Where the celebrity themselves is the first tweeter and you just retweet, and the celebrity themselves says, hey, I love this ice cream, you're probably pretty safe. Your lawyer's going to tell you, yes, you should try to get something in writing. And you also see this, the kind of down and dirty way to get this done, and it's effective, is you just tweet right back at them and say, great, thanks for coming by. Okay, if we retweet. And she says, of course. And then you do it. And now you've got it right there. You don't necessarily always need to go through the lawyer paper. Where you get in more hot water, though, where we've seen big lawsuits, is when that celebrity wasn't the first person to tweet. Britney Spears comes in to get some ice cream, and one of the owners or someone there thinks that's really cool, takes a photo, and then the business posts it and say, hey, look, even Britney Spears loves our ice cream, and she came in today, and we're her favorite, clearly. And Britney sees that, and her publicists see it. they're going to go through the roof. Because take a step back and think, okay, now I'm ice cream or frozen yogurt business owner, and I want Britney Spears to be my sponsor and endorse us. How much do you think Britney Spears is going to charge you for that? It's going to be a big amount. And that's that right of publicity that I referenced earlier, that we let celebrities and other people control the commercial use of their image, their name, their likeness, because, you know, people give up a lot of privacy to be a celebrity. And so we like to make sure they can get paid in, you know, exorbitant amounts. There was an example of this a few years ago with Katherine Heigl, who went into a Duane Reade pharmacy drugstore up in New York. And they did just that thing. They got a photo of her coming out with a Duane Reade bag, and they tweeted, "Hey,
the paparazzi
even
shot.
Katherine Heigl can't resist coming to Duane Reade." She sued for $6 million.
Wow.
And she had a case.
Yes,
It settled. It settled with an undisclosed donation to her favorite charity or foundation.
It just seems like that could have been handled so easily with a phone call and some paperwork. And call it a day.
Right, and to be clear, there was no copyright issue there. If she was in the photo, she didn't take it, she couldn't sue for copyright infringement. I think we can assume that, however that happened, Duane Reade actually got ownership of the photo. They probably dotted that I, crossed that T. See, we own the photo, let's use it. And then they got hit with a $6 million lawsuit. So you've got to watch out when you're using other people in a way that makes it seem like they endorse or sponsor your products or your services.
So going back to that point you made, if you were in that store that she was in, and you took the photo, even though you're not paparazzi, you're not media, you just happened to be buying some Snickers because you were hungry or something or the other.
Right.
And you take that photo, and then you proceed to post it on Twitter and whatever else. What trouble can that get you into?
Not too much. I mean, she's a celebrity. She's newsworthy. She's out there in public. If I'm using it not as a commercial, for a commercial purpose, and it's personal, I'm just putting on my Facebook saying, "Hey, guess what? I was buying a Snickers and I saw Katherine Heigl." You know, that's going to be pretty safe. It's First Amendment. I can tell people what happened today. She put herself out there. Now, I can't go to her house and take a picture over her fence and say, "Guess what? I was hanging out outside her fence today," and that's different, right? That's a different privacy concern.
That's called stalking.
But as long as it's personal use, it's pretty safe.
Okay, now we've cleared that up. So, let's see. I have a couple of more questions. Just a couple of more questions. You got a little bit more time? You have a little bit? Okay, sure. Okay. So, when is the most ideal time to get that release? Is it pre-production, because we both have entertainment background? Is it pre-production, production, or post? Pre
development. I mean, pre as early as possible, because people change. Early on, things are, no one knows what's going to happen with a project or with a business, and it's easier to get that taken care of. Once somebody knows you've invested a lot of time and energy into something, or they smell that it's going to be a success, their price goes up, because suddenly they know you need me to sign that piece of paper, or else you have to undo everything you just did. So let's talk money. And I've seen that time and again. So get that piece of paper early before they know you really need it and you've made a mistake.
Okay, so you heard it, people. Get the release created and get it signed before you go out and start doing your shooting, before you start doing your interviews and things of that nature.
Right.
Okay.
Because if I'm the person you need a release from and you haven't started yet, I know that if I say no, you're just going to go to the next place or the next person, and you have other options, and so I can't demand that much. Yeah. If you spent 3 days or 2 days and you've spent money and you paid employees, I'm now thinking, your second option doesn't look that good anymore, and I can get a little more money for my release. Okay.
And so that also applies to live streaming. I would imagine live streaming is going to create some new clients for you in the very near future, because everybody seemingly likes to go to the concert, likes to go to the festival, You like to go to whatever the event is. You shoot a little. You're on Periscope. You can't resist live streaming.
Right.
30 seconds of the concert. Just a little bit, just a little taste.
See it all the time. The new lighters.
Okay. And at that particular point, you could potentially get yourself in trouble. Correct?
Absolutely, you could. It's very interesting because that's really a business decision. Mm-hmm. On one hand, you say you represent the owner of the music. People are digging your concert, and they're out there, and they're giving you publicity, and other people are watching it, other people are hearing it. So that's one of those practical considerations of, sure, just because you have the right to stop this, because you are engaging in copyright infringement. You're taking this work, and you are broadcasting it, and you are copying it, and sending it somewhere else to be seen. But the question that you go through, and it seems like most bands and musicians are realizing that probably not in their best interest, big picture, to shut that down because, hey, that's free advertising for them. On the other hand, sports is where you would most likely see a business decide that that's worth pursuing. I'm at a game, and you always have the, do not rebroadcast any part of this game without all of our permission, or you're going to get sued. And I'm sitting close, and I've got my Periscope out, and I'm broadcasting what's going on in front of me. I wouldn't mess with that.
Okay.
Those sports leagues come down hard on things like that.
I would imagine so because Periscope a couple of years ago got in a little heat because of one of the major fights that was going on. I think it going on in Vegas, and because people were literally like, "Why go to the fight? I can just watch it on Periscope."
right. And then they have these big money contracts with pay-per-view. And people aren't doing that, and so then the sporting league will have its own outside pressure from whoever's providing the pay-per-view for them to come down hard on you.
Okay. So last question: in creating your social media policy, are there some standard things you should have in your social media policy? Just some general things, or is it just best just to call you and have you draft it for the business?
Right. So they're not one size fits all. That you're talking about kind of your terms of use, privacy policy.
Mm-hmm. Yes.
Yeah, they're not one size fits all. They actually create a contractual relationship with the people who use your site or follow your blog, or whatever it is. There are some things that you want to address in there, especially in privacy policy. You want to make sure you're telling people what kind of data you're collecting, what you're doing with that data, how you're using it. And as long as you're upfront, transparent, truthful about that, then you're going to be going in the right direction. So those things need to be in there. It does help to have someone who knows what they're doing flush that out with you, so you can think through exactly what it is. You might forget, oh, that's right, I am actually capturing IP addresses, so I can kind of get a geographic feel for where my visitors are coming from. That kind of stuff is important. In terms of use, it's so tailored to what you're doing. A simple blog might have a need for no terms of use or very short ones. If you're engaging in e-commerce or you're publishing things, you might have more robust. I will say this, and this is something that's often missed. There is a part of the Copyright Act, not 1970s, Congress put this in the late 90s because they realized the internet was going somewhere and is going to be a thing. It's called the Digital Millennium Copyright Act. And it has a provision that if you have a website where people can post content, so not you, but other people. I mean, this is the Facebooks, the YouTubes, where other people are putting their own content. If in your terms of use you have a designated agent and you have the way to contact that designated agent, and then you've put that designated agent on file with the U.S. Copyright Office, both those things have to happen. You could be totally insulated from copyright infringement that occurs on your site if you follow the right steps once you get that notice.
Wow.
This is why you can't, if you see on Facebook somebody posted something that infringes your a photo that you own and it's infringing, you can't sue Facebook. They're going to fall under this law that protects people who operate sites where other people post content. So it's kind of a little bit of a tangent, but that's something that needs to be in your terms of use for you to even qualify for that safe harbor.
Okay. So if, like, for a lot of small businesses, will they need to have a social media policy? And usually when you think about a social media policy, you think big business, but small businesses need to have a social media policy just as much as a big business would, to a degree. Yeah,
they probably won't look the same because they'll probably have fewer risks, or the risk won't be as severe. But if you're engaging in it, it's a good idea to make sure you've looked at policies and make sure you have ones that cover what you're doing and where your potential exposure is.
Okay. I have a question from one of my students.
Okay. Great.
Yeah, you can speak it. Go ahead.
Okay. So I have a question about something happened to me last year. I posted an Instagram picture.
She's talking about an Instagram picture. Okay.
Ice cream shop.
Okay.
Of an ice cream shop.
And then later on, I saw that it was on all these other food Instagrams.
Uh-huh.
I saw it in the newspaper.
Oh, you saw your photo in the newspaper.
Yeah, on an advertising.
On an ad.
So no one ever asked me for my.
And nobody paid you any money?
No one ever asked
You might need to call Thomas here.
Is that copyright?
Thomas, she wants to know. Technically,
okay.
if that kind of thing happens, you take a photo of an ice cream shop or anything, and where did you post it initially?
It was on Instagram.
On Instagram, because people, well, that's another source of, like, that's almost like putting it on Flickr. You've heard of Flickr?
Yeah.
And technically, you got no compensation for that photo, even though it was in an ad. I would dare say she has a. You need to talk to Thomas. I'll get you his information.
So you took the actual photograph. You weren't in it, but you actually snapped the photo.
Yes, she took it.
Yeah. That's the classic case of using a photo that doesn't belong to you and you didn't clear. That business sounds like committed copyright infringement. Whether what you want to go after, what your remedies are, can really vary based on a number of factors. But yeah, sounds like they infringed your copyright interest.
I hear cha-ching in your future. Okay. What's your question?
Signing events, at local high schools.
Signing events at local high schools?
Kids who are going to public
with kids?
Yeah. Mine is, school's permission. We have a problem with that.
Yeah, if especially if you're shooting kids, you definitely need to get something in writing if you're shooting kids, right? Yeah, yes. That's pretty much a given, and that needs to be posted everywhere. It's just like, even if the school has authorized it. I'm talking to a nonprofit owner, and once again, if you're shooting images of kids, just as I told you this day one in class, even if you are taking pictures of kids, always get permission. That's a backup.
Right.
Yeah, you can get release forms. You got release forms on the internet all day, every day. However you will want.
Make sure their parents sign them.
Make sure your parents sign them, but you will want to customize that to what you do. So don't go so general that you leave room in there. Now I know that I see your face as, damn it, there's more work I got to do. But in the end, you'll save yourself from being sued. So, and you're a nonprofit. You want to keep your nonprofit. Okay. Any other questions? General questions, because he is not here to be a lawyer. Any other general questions? No? All right, then. Oh, thank you, and thank you again. And I apologize for all the technical difficulties. When you're doing something for the first time, it's new. It is what it is. So, but we got it done.
I was happy to be your guinea pig. Thanks for having me.
Thank you, sir. So for those of you that are watching this on Facebook, watching the replay, thank you. And for those of you in class, there will be a pop quiz. Okay. So I'm going to end this now, and I'll let you get on with the rest of your night. And I'll talk to you via email later.
Perfect. Thank you very much. Bye, everybody.
Bye-bye.